welcome to another edition of John's Rants. Hopefully you've been enjoying these presentations. Today's topic is going to be buyer-broker representation agreements. In litigation, particularly litigation after the close of escrow, most of that litigation will be filed by a buyer. Buyers that believe they didn't get the services that they were promised, the buyer didn't get the house that they thought they were getting. And of course, as the buyer's representative, the burden will fall on the broker and the agent to establish that the fiduciary obligations that you had were taken care of. Part of the problem with that is that oftentimes a real estate company will represent a buyer, but without any written agreements. Therefore, it's going to be up to the buyer's agent to establish what they thought they were supposed to do, what the buyer thought they were supposed to do, and I believe that's a mistake. CAR has a couple of forms that I think realtors should use on a more regular basis. It's been my experience as a defense attorney that realtors don't often use the buyer representation forms, and I'm hoping to make a case today why I believe that's a mistake. First of all, these are agreements that are between the buyer and the buyer's broker, and the purpose is to cover the representation and to establish not only the commission issues, but also to establish what the representation will and will not entail. The key features are that it lays out the tasks and the obligations that a realtor has. That would be paragraph 5 of the agreement, but in paragraph 6 it makes it very clear that there are going to be things that you're not going to do. Sometimes a buyer thinks you're going to go check permits, or that you're going to measure the property for square footage, or do all sorts of other things that in reality you're neither capable of doing or unqualified to do, or that specifically a statute says you shouldn't do. So this defines the scope of the duties that you're going to be performing. It provides a written consent in the event that down the road the representation becomes a dual agency representation. And it also provides for, under certain circumstances, revocation of the agreement between the buyer and the agent. There's 3 types of forms. So there's not just one form for all purposes. One is what I would call the flip side of the listing agreement. That's the exclusive form. Then there's a form that, while it's not exclusive, says that if you do represent the buyer, you're going to be promised a certain amount of commission, regardless of what commission is being paid by the listing agent. And then lastly, there's absolutely no money. There's absolutely nothing to tie you to the client. But if you do represent that client in a purchase of a property, it simply defines the do's and the don'ts of what you're going to do. So the buyer representation form that is not exclusive is revocable, and it's not exclusive. They can use whoever they want. The non-exclusive representation that does provide for some commission. By the way, the one that has absolutely no strings attached is the BRNN. Then there's the BRNE form. That's the buyer representation agreement that is non-exclusive, but provides how you're going to be compensated for certain services. And it provides that if you're paid, they'll deduct the amount that the seller and the seller's agent pays, and it makes it non-revocable. But it does provide that you're going to be guaranteed a certain amount of money. It has a definite commencement date, a definite termination date. There are mediation clauses. There's an optional arbitration clause, and there is an attorney's fees provision. Then there's the BRE, which is, in my view, as I said, the flip side to the listing agreement. It provides specifically for compensation. It is non-revocable. It provides that you will be the exclusive buyer's agent for that buyer, and that regardless of whether they buy the property from your office or somewhere else, they will be obligated to pay you a commission. Definite commencement date and a definite termination date. There's a safe harbor provision in it, and there's mediation and arbitration clauses and attorney's fees provision. So why use these forms? Well, a couple of things. Number one, it puts the duties and the obligations that you are going to provide them in writing. you already know that you have many statutory obligations. You have many responsibilities that the courts have imposed on you. But there are some things that people think you have an obligation to do that you don't. Some of those things are listed in paragraph 18 of the RPA contract, and there's a scope that you're limited. You don't, for example, decide the highest and best use for the property. You don't decide how much to pay. You don't go off-site. You don't check permits. You don't check public records. So this says all that. So it puts your duties and obligations in writing. It also informs the buyer of your responsibilities at an early stage so that it sets their expectations. It makes it clear what you're qualified to do and what you're not qualified to do. It identifies the services that you're going to provide and what you're not going to provide and what others will provide. It allows for negotiations relative to the terms of the relationship. It does provide consent for dual agency if that's going to happen, and it brings clarity and certainty to the relationship. At some juncture, if there's a dispute over who the procuring cause is for that particular buyer, it could even be used in a hearing to establish procuring cause. So for all of those reasons, I believe that it's a very valuable tool. There was a case that was decided back in 1998 called Fields versus Century 21 Clouden. And that case did a couple of things. Well, first of all, it talked about the difference between representing a customer versus representing a client. If you're the listing agent, for example, the statute of limitations against you is 2 years if an action is brought by the buyer that your firm did not represent. But in a fiduciary duty situation, the Fields case said that the statute of limitations is 3 years. But then the court went on to say that there's another issue that's very important, which is if you are representing a buyer, you're required under the Fields case to literally step into the shoes of the buyer, anticipate the information that the buyer should know, and then provide it. Later on, the jury instructions were amended, and it now specifically says that, in fact, what it says in that jury instruction is the broker must place himself or herself in the position of the client and consider the type of information required for the client to make a well-informed decision. It's a very difficult standard. Sets up some unreasonable expectations, and sometimes, frankly, the information you're simply not qualified to give. So what it does in this scenario is it clarifies what you will and what you won't do. Now, it's not required by law. There's no statute that says that you have to have a buyer representation form. As you know, there is a requirement that you have a written agreement for a commission from a seller, and of course the seller's agent will then pay that commission in a shared way to a procuring cause agent. However, there is no requirement, but again, in any professional relationship, whether it be with a lawyer, whether it be with a realtor or whoever, it's a good idea to have a written document that specifies specifically what you are going to do. Some offices actually require their agents to use this form, and I think that's actually a good idea. The courts have upheld these buyer representation agreements as being legally enforceable. So, in closing, I think it's best to have a buyer sign these agreements, frankly, at the earliest stage. You can provide it with the agency disclosure before you prepare an offer. You can give it to them at whatever stage you deem appropriate, and of course, which one you give them depends upon whatever your office's policies are, whether it's going to be exclusive, non-exclusive, for compensation or not, so that you can use the correct form. You can use it with the consent for representation of more than one agent, more than one buyer or more than one seller. Again, in looking at it from a perspective of the Code of Ethics, Article 9 of the Code of Ethics specifies, I'm going to read this to you, Realtors for the protection of all parties shall assure, whenever possible, that all agreements related to real estate transactions, including but not limited to listing and representation agreements, etc., be in writing. Now, NAR does not require that the California associations enforce the representation agreements in writing because, frankly, it's been historical that in California we don't use representation agreements, and I think that's a mistake. I think that wherever possible, for not only the protection of the client, but for the protection of the brokerage, that you should consider using these forms because, again, why do we put agreements in writing? So that there's no misunderstanding about what the deal is amongst all of the parties. Standard of Practice 9.1 says realtors shall use reasonable care to ensure that documents pertaining to the purchase, sale, or lease be in writing, and that 9.2 talks about making sure that listing and representation agreements be in writing, even if those documents are passed electronically. So how do you broach this with your client? I just taught a risk management class here while I was up here today, and we were talking about how do you present certain kinds of things to your client. Sometimes you do it in a way that makes it look like all you care about is your own self-interest, but the reality is that putting these agreements in writing protects the client every bit as much as it protects the real estate professional, because again, the client can see what it is that realtor is going to do for them. And I think when you talk to the client, you need to make them understand that it clarifies and puts in writing all of the different variations of things that you can and cannot do. And it reminds them that it will protect their interest as well as your own. So for all of those reasons, I think that the use of these buyer representation agreements is a good idea. I think it's something that's underutilized. When you don't have it in writing, now it's up to you to establish the parameters, and it makes it more difficult down the line if there's a mediation or an arbitration or even a litigation. So again, I'm urging you, get rid of people like me. Use these buyer representation agreements. I think you're going to find them very beneficial, and I strongly suggest that your office consider using them. Thank you very much, and we'll see you next month. Probably going to talk about the contingency removal issues next month. We might even start talking or starting a little conversation about referral fees. So until then, we'll see you again.